Hi, welcome everyone. I'm Jeannie Fromer. I'm a professor of intellectual property law and vice dean for intellectual life at the law school. Welcome to Respectfully Dissent, a relatively new series at the law school where you get to experience your own professors debating the most important current legal and policy issues. Today's our second event, and more on that in a moment. As I noted at our inaugural event a few weeks ago, since the mid-1900s, US Supreme Court and state Supreme Court justices regularly started ending their dissenting opinions with "I respectfully dissent." It was a way of disagreeing while also communicating to their colleagues and the public that even though there might be a sharp disagreement on the legal issue at hand, they retain respect and cordiality to their colleagues on the other side of the issue. And it's in that spirit that we are having this Respectfully Dissent series. Your law professors here sometimes have sharp substantive disagreements with each other, but we also like and respect each other and value having discussions about those disagreements and walking away with respect and admiration for each other. And also, we learn from each other. Sometimes we're persuaded by each other. Basically, we can be on opposite sides of the V and also be supportive colleagues at the same time. Okay, today's event is about judicial review. Is judicial review a desirable feature of a modern constitution, or is it undemocratic? And I'm delighted to have two of my brilliant colleagues here today to discuss that topic. On my left is Sam Issacharoff, who is the Bonnie and Rick Reese Professor of Constitutional Law. And on my right is Jeremy Waldron, Professor of Law and University Professor here. There are many more fascinating aspects to their biographies, and some of that I have no doubt will emerge during the discussion, so I want to turn to that. Each of them is going to speak for a little bit, then have some discussion with each other, and then we're going to leave some time at the end for Q&A. So with that, I will turn it over to you.
Thank you, Jeannie. Thank you for setting this up. I have no problem at all with the respectfully side of this. I have enormous respect for Sam Issacharoff. I've known him for many years, since he came to Columbia from Texas. When was it, Sam? 1999?
8, I think, something like that.
And we've been arguing about judicial review ever since, which shows how entrenched some of these positions can be, even in the midst of the respect and admiration that I'm sure will be on show today. So the problem is a problem about judicial review. The particular practice that we have in constitutional law, which permits statutes, pieces of legislation by federal and state legislatures to be struck down and for them not to be enforced because of the decision of a simple majority of justices on the Supreme Court, or the matter stops at one of the circuit courts on the basis of a simple majority among judges there. Sometimes the decisions are unanimous, sometimes there's a supermajority, but our rule and our practice is 5 votes speak for on the Supreme Court. And so we are interested in the implications of that particular arrangement. We know that this allows panels of judges to determine finally what the verdict of our society will be on a whole range of watershed issues. Abortion, affirmative action, anti-discrimination, capital punishment, these are sort of in alphabetical order, capital punishment, church and state, conditions of imprisonment, the rights of criminal suspects, defamation, the treatment of detainees and the war on terrorism, the disenfranchisement of prisoners, flag burning, free speech in general, gay rights, including same-sex marriage, gun control, hate speech, language rights, military service, minority cultural rights, policies on obscenity and pornography, and on and on and on. On these issues, which are major issues on which you get intense disagreement in the society among citizens, among civil society organizations, intense disagreement among representatives and candidates for representation, intense disagreement among officials, and, surprise, surprise, intense disagreement among judges. This is not working. Intense disagreement among judges. On these issues like these, the society's final position may be settled by legislation, but if a panel of judges decides to intervene on the basis of simple majority rule, then the complex majoritarian arrangements of the legislature, and think how complicated legislative decisions are, bicameral, involving executive signature or the overriding of an executive veto, multiple stages, various points of unilateral veto within institutions like the Senate, committee stages and so on. We have a very, very complicated system of majority decision by legislatures. And our practice of judicial review, which is what we're talking about today, allows that to be stopped in its tracks by a simple, crude majority decision among judges who disagree with one another on the same basis as the representatives disagree with one another, on the same basis as the citizens and officials disagree with one another. And so we worry about the problem of allowing judicial power in that way to affect the basic policy of the society. As Abraham Lincoln put it once in his first inaugural address, the candid citizen must concede that if matters of general importance for the society are to be settled the instant they're raised in litigation between parties by the Supreme Court of the United States, then the people will have ceased to be their own governor, having to that extent resigned their power to the members of that eminent tribunal. And that's the problem that I want to highlight, the problem of the democratic or the undemocratic character of judicial review. It's sometimes called a counter-majoritarian difficulty. This is Alexander Bickle's phrase, but it's not counter-majoritarian. There are majorities all over the place, and this allows majorities among judges to decide certain matters. So it's not a matter of majorities, it's a matter of who the majority constituency is, or a majority of whom are allowed to decide these matters. And the suggestion from the Waldron side of this respectful disagreement, the suggestion from the Waldron side is that there is something problematic about that practice from the point of view of democracy. There's something problematic about that practice from the point of view of democratic legitimacy. There's something problematic allowing these matters to be settled by majority voting among judges, an unrepresentative array of judges, lawyers, Yale Law School graduates, Harvard Law School graduates. If you look at the religious credentials of the judges, you find there isn't a great deal of diversity there. There is a very considerable contrast between the diversity of our legislators and the diversity of the judges. But nevertheless, we allow the judges to settle these matters. We allow them to settle it by simple majority voting, even though we could have set up a system of supermajority requirement so that legislation may only be struck down by the court if 6 or 7 out of the 9 judges votes to strike it down. Some states have that as a rule for their state Supreme Courts. North Dakota, I think, and Nebraska, I believe, both have requirements of supermajority rule. Or we could insist on unanimity, wanting to preserve a strong presumption in favor of the democratic solution, in favor of the democratic solution, with no striking down of legislation, no refusal to apply legislation, except pursuant to a unanimous verdict among the judges. And I don't know, I hope we'll have a chance to discuss those options and those possibilities today. But I think the simple majority idea is perhaps the least defensible form of judicial review. It's a practice that plays havoc with our assumptions about legitimacy. And I want to just say a word about that. Legitimacy is a difficult concept, and there are different definitions of it all over the place in political philosophy. I'm a political philosopher as well as a legal philosopher. there are different definitions of legitimacy all over the place, but the one essential idea of political legitimacy envisages a situation where there is disagreement, massive, good faith, principled disagreement on some issue, like one of the issues that I mentioned, and where a decision nevertheless has to be reached by the society as a whole. And so there are going to be winners and losers in terms of people's views and what that outcome, what that decision should be. A decision is legitimate if there is a way of reconciling those who lost in the decision making to the upholding and imposition of the decision that prevailed in the decision procedure. If there is something that we can say to the losers, we understand you lost and we understand that you continue to disagree, but here is why you should perhaps comply or fall in with the decision that we have made here. Here is why it is a legitimate basis for the exercise of power in your situation. It's a legitimate basis for the exercise of power over you, despite the fact that you disagreed with what the outcome was. We have to be in a position to be able to reconcile our fellow citizens to the decisions that we make. And my worry is that judicial review suffers from a sort of legitimacy defect, because all we can say is a majority of judges voted against you on this matter, majority of wise justices, a majority of serious-minded justices, no doubt, but these were unelected justices, justices who had no democratic credentials to their name. Whereas, when the decision that was struck down was passed by the legislature, it had a relation, a complicated relation certainly, but a relation to majority voting among the citizenry. And it represented a process, a complicated process, but a process nonetheless, in which everybody in the society was given an opportunity to voice their opposition, and everybody in the society was given a vote that was as strong as possible for each member of the society, compatible only, conditioned only by the requirement of political equality among all the members of the society. So if we can say something like that, we can say, we understand you still disagree, but at least there was a fair process that yielded the result. And my worry is, and what I hope to be persuaded today by, is if Sam can point out some basis for thinking about legitimacy that doesn't require us to abandon democratic principles. So I'm going to stop in a minute, but I hope that we can debate this on a number of fronts. One important distinction, and please bear this in mind in the discussion that follows. One important distinction is that if we are going to try to defend this practice, which I think we're stuck with, this practice of judicial review, we're stuck with it. I'm not disputing that it is an existing part of our constitutional arrangements. It's not, as it were, illegitimate in that sense. People support it. It's been a part of our constitutional arrangements since Marbury against Madison was decided in 1803. And there may be questions about whether it should be set up in other societies, but here it is here, and we're stuck with it. The practice, which I'm saying we are stuck with, can be defended or evaluated in terms of the outcomes it leads to. It's a good system because it leads to good outcomes, or in terms of the process and procedural values that it embodies. It's a good system because of the respect it accords to the people who participate in the decision making. I believe we have to deal with both of those criteria for evaluating a practice or evaluating a decision-making institution. Good outcomes? Don't know. I'll have a word or two to say about that. Good procedural values? I'll certainly have a word or two to say about that. I believe that those need to be evaluated separately and together, and I think that we have to try to figure out a way of making ourselves comfortable with this institution that, as I said, there's no question of it being abolished, although people are less enthusiastic about it now under the Roberts Court than they might have been 10 years ago, 20 years ago, anyway. So I'm going to leave it there, and I look forward to hearing what Sam Issacharoff has to say on this matter. And again, Jeannie, thank you very much for setting this up.
Okay, is my mic working? Yeah. So Jeannie, thanks. This is wonderful. It's not the first time Jeremy and I have exchanged ideas on this subject. Jeremy has been one of the singular intellectual influences on me in the over 25 years we've been colleagues. He moved to Columbia a year before I did. I moved from Columbia to NYU a year before he did, but basically we've been working in the same domains in the same institution for a very long time. And sometimes it's a little embarrassing to redo this debate. I think our most embarrassing moment was when the two of us were asked to comment on a new book by Justice Albie Sachs of the South African Constitutional Court, who came to NYU, and in no time, the two of us were fighting with each other, and poor Justice Sachs had the look of somebody who goes to a dinner party and all of a sudden the hosts are divorcing, you know, and it's and that was not our finest moment. But let's see if we can do it a little bit better. So the crux of the disagreement is one that is really beyond judicial review and is one about the inclinations of our methods and how we look at the world. Jeremy, as he said, is a philosopher. He tends to have to look for idealized principles and then to distill them, and this is unique among political philosophers, distill them down into what kinds of institutional arrangements should be had. And you must appreciate what a breath of fresh air this is in political philosophy. It's why he's been so significant. It's why, despite the disagreements, there's such a tremendous overflow of ideas and influences that comes from his writings in this area. I tend to look at things in the other direction. I tend to be bottom up. I tend to look at lived experience and then see what kind of theories I can map onto the lived experiences to give the best account I can of institutional successes, institutional failures. And so when I look at judicial review, I start not at the level of assuming or hoping for idealized democratic processes. In Jeremy's writings, he refers to certain conditions of robust debate in the legislature, bicameralism, healthy parliamentary procedures that integrate the minority well. He has a whole series of conditions that are a very beautiful, idealized version of democratic exchange, and says, where but the legislature can that occur best? And he speaks of this very movingly as the dignity of legislation. He really believes in that legislative process. I come at this from a different perspective, in part because I am less concerned with the rights domain. And the list that Jeremy gave you at the beginning of all the from affirmative action and abortion on, we didn't get to Z, but we got close enough. That whole list is pretty much a rights catalog. Who should decide whether there's a right to abortion? Who should decide what rights of incarceration there should be, et cetera, et cetera. I come at it from the other perspective. I say, well, let's start with the idea that we're trying to maintain a system of democratic governance. And what are the disabilities of democratic governance? What are the characteristic disabilities of democratic governance? And how does legislative primacy play into that? Now, I don't dispute that the legislature has to be the core of any democratic system. It's Article 1 of our Constitution, not by accident. It is where democratic processes, if working well, should play out. But do they always present themselves? So let me give you two major problems of our day. One is that sometimes legislators act in contradistinction to the interests of democracy. And what's going to happen there? A lot turns on the rules of administration. Democracy is fundamentally about repeat play. We win this time, you win next time. We know that the rules are such that, that each of us can take our turn in office. There's rotation in office. What happens if the legislature, in manners that are self-interested, begin to close up the political process? Now, we don't have to, the most obvious, of course, is legislation that prevents blacks from voting or women from voting, things of that sort. But let's go more deep down. Assume, for example, that a legislature has to be voted on by the people, and that people must have some kind of equality in their presentation before the voting possibilities. What happens if the legislature says, hey, you know what? I don't want to reapportion the seats of the legislature because that's going to give out groups more of a chance to get in, and it's going to diminish the power of those who are there now. What if they did that? Well, in fact, that's the history of the United States in the 20th century. That's basically the history from 1910 until the 1960s, where state legislatures and Congress refused to reapportion because there was the fear that power would shift to new communities, away from rural areas to urban areas, away from traditionally white areas to areas that now had immigrants and then blacks who could vote and so forth. And all of a sudden, there was a refusal. So what happens when the legislature, and this is the term that Rick Pildes and I use, lock up the political process? Where are you going to turn? And an important concurrence in a case called Baker versus Carr, Justice Tom Clark said, you know, at some point, the conscience of the public can't be mobilized because the system is closed up. And that's why you need judicial intervention, because there's no other body that can do it at that point. And this is not simply an American story from the 1960s. It's a story that every democratic country has confronted. You have public subsidies of political parties in Europe. Great. Guess what they want to do? They want to constantly increase the public subsidies and limit the number of parties who can get public subsidies. What a shock that they think that they are the best exponents of the best interests of the society and should be rewarded economically in turn. That's another possibility. So what happens there? Court after court, beginning with the German Constitutional Court and then spreading through Eastern Europe, intervenes and says you can't do that in a way that forecloses political competition. And political competition turns out to be central to democracy, and political competition organized through political parties. And that's something that we recognized in the United States. This is the heart of the theory propounded by John Hart Ely of process values to make sure that the avenues of democratic contestation are kept open. This is the work that Rick Pildes and Pam Carlin and I have been pushing for the last 20 plus years. Then you go around the world and you see the same thing. So go to Taiwan. In Taiwan, there was basically a dictatorship by the Kuomintang beginning in 1949. In the 1990s, they started to lose power, and all of a sudden they were challenged electorally. So the legislative yuan, democratically elected under the rules of the time, passed a law that said, we're going to suspend elections for a couple of years. Whoa, how about that? And we're going to say that from here on in, the legislative yuan, basically the equivalent of our House of Representatives, will have percentage allocations that reflect the percentage allocations today. So they locked in permanently their legislative majority. What happens? Who can intervene in that circumstance? It has to be the court, and that was the first major decision by the Taiwanese Constitutional Court, interpretation number 499 in 1999. They struck that down, and Taiwan is a thriving democracy today. What happens in India? You have Indira Gandhi being challenged on some of her basic policies, and you have the declaration of the state of emergency, the expansion of executive authority, and the foreclosing of judicial review of the actions taken by the Congress Party, which was dominant in the legislature. And the Indian Supreme Court, and this was a signal move that has been followed by courts around the world, declared the doctrine of basic structures of democracy and says, you can legislate on whatever you want. You cannot alter the basic structures, meaning that you must maintain the political accountability that was there. We saw the same thing in South Africa, where the African National Congress came out of the negotiations for the end of apartheid with too strong a majority. They got to the parliament, and which was also sitting as the Constituent Assembly, and they voted themselves too many majoritarian powers. The first major decision of the South African Constitutional Court, the certification decision in 1996, was to strike down the first constitution as being unconstitutional. You got to work with that a little, but nonetheless, it was the idea that they violated the basic pact that allowed South Africa to peacefully transition from apartheid to a multiracial democracy. And so what these instances have in common is that they ask a question not about the rights domain, but about the basic structures of democratic integrity. And there's a reason that we don't let the players in the middle of a baseball game negotiate the rules, and we don't let them change it. You have to have an outside arbiter who enforces the rules of the game. Otherwise, the temptation to lock yourself in power is too strong. That's point number one. Point number two, and I hope I'm not going on too long, John. Point number two is there's another feature of the democratic world today, and this is a sad development, and I think it really traces back. It has its roots further back, but it's really come to the fore in the last 15 years or so. And that is, it is a characteristic of virtually every democratic country in the world today that the legislative branch is failing. The legislative branch is not the center of policy determinations. It is not the center of political debates. It is not the center of the type of legislative engagement that Jeremy sets out as the ideal. And instead what we have, and in my writings I attribute this largely to the breakdown of the party system, which brings coherence and organization to legislative politics, and I think that's a source of disagreement. Also, I've always said that you underplay the parties in your list.
Yeah, I ought to say more about them.
And you will, if I know you. But the problem is that the legislature is not playing its role. And so what's the threat there? Well, in some instances, it may be that the courts are too active, and there are examples of the courts being preemptive, in some cases, downright destructive. The Venezuelan Constitutional Court, at the behest of Maduro, abolished the legislature, right? The Bolivian court, at the behest of Evo Morales, abolished limits on the tenure of a presidency. The Nicaraguan court did the same thing. And you see that these institutions can be captured, and certainly the Hungarian court has been a dreadful institution as Orban has consolidated power. But it's generally not the courts that are the problem. The problem is that power has passed to the executive branch, and the executive branch now, in country after country, dominates the legislature. And keep in mind that we have a presidential system which is supposed to instantiate some kind of separation of powers. In a parliamentary system, the chief magistrate, the chief executive, is the head of the majority party in parliament. And so it's not structured around separation of powers. And so long as the prime minister is truly accountable to the parliament, you have some sense that there's a difference in function between the executive and the legislative function. The legislative function can still be the site of deliberation and prime minister's hour and all that tea and crumpets and all that British stuff that, that we all so love. But what happens when it fails? Then all of a sudden the majority caucus in the legislature basically reorganizes itself as the cabinet, And then you have the same kind of problem of executive unilateralism that you get when you have a president who is not checked by Congress. So in my sense of this, judicial review of executive conduct, and I know Jeremy does not disagree with that part of it, with the judiciary being necessary to review the executive, but judicial review of executive conduct spills over into judicial review of legislation, because when you get somebody like Orban, when you get somebody like Kaczynski in Poland, they find that the easiest way to govern is just to ram through endless amounts of regulation and law, which serves as the instrument of the suppression of dissent, the instrument of maintenance of themselves in power. And so the line between executive and legislature is blurred, and the judiciary is called upon to confront both. And the downside of this story is, in most such cases, the judiciary ultimately loses because they just can't hold off against the concentration of power. But so from my perspective, and I'll stop here, from my perspective, looking at where the weaknesses or the likely failings of democracy are, the legislature doesn't come out quite so clean. The legislature comes out oftentimes as an actor seeking to curtail its own political accountability. And in those instances in particular, the need for judicial intervention is greatest. Oh, can I just say, I don't disagree with you on the voting rules in the, I conceded that one years ago.
That's good. Listen, this is terrific, and it's an enormous contribution, and that's exactly the reason that I enjoy working with Professor Issacharoff on these matters. He keeps me honest in the sense that he insists that I come down from the clouds a little bit and consider the institutional arrangements, institutional processes, issues of institutional competence, and the institutional vulnerabilities, which I think we've just had a very good outline of. So all of this is important, and this is a good terrain on which to argue the issue about judicial review. I do think, and I hope Sam will have the opportunity to say a little bit more about this, that we need to have some tissue of connection between the considerations in Sam's 2 points, the considerations that both reflect the possibility of political process being locked up in various ways. We need to have some connectivity between that and the particular issues within a Bill of Rights that tend to be the subject of judicial review. Because, I mean, I know Sam said he didn't want to remain in the lofty arena of rights and rights theory, and I respect that. But still, you can't help noticing that judicial review is often, not always, but often oriented to upholding issues about rights on which the citizens disagree and on which the representatives disagree and on which the judges disagree. So we need to map the important considerations that Sam has developed onto issues of rights and see how they survive that mapping. Let me just offer, and this is really a friendly supplement to Sam's presentation. We know it is possible that the legislature can act in ways that lock up the political process and make it very difficult for the political process to operate in ways that idealists about legislation and the dignity of legislation may desire it to act. One way, I think, which is enormously important, is that theoretically, and in the ideal theory of the dignity of legislation, I want to emphasize that we legislate in complex ways so that it is possible for legislative minorities or for representatives of minorities in the society at large to play a part in that legislation, to insist on certain conditions being satisfied, to insist on certain contributions being taken seriously in the course of legislative debate and in the course of the manufacture of legislative positions. We think it's very important that if minorities have concerns about a piece of legislation, that in the first instance they don't immediately go into an oppositional posture, but they say, look, we have concerns about this. What can you do about that so far as rephrasing or reorganizing the legislative proposal is concerned? We have ways in which minorities and majorities work together within the legislative process. And from time to time, that particular aspect of the legislative process gets locked up or gets sabotaged or doesn't work properly. And then we have, I think, the second part of the John Hart Ely approach that Sam didn't talk about, which is how to think about how legislative processes work when minorities that are, as Justice Stone said in the United States against Caroline Products, 1934, I think. What do we do in situations where minorities are discrete, utterly separate from the rest of the society, insular, with no clear ties to the rest of the society, making it much harder for their objections to be taken seriously, for their participation to be seen as part of a coalition, for their contributions to be entertained in the legislative solution? In some circumstances, we are worried that that way of organizing majorities and minorities working together, forming and reforming coalitions, forming and reforming majorities, that goes wrong, and we want to pay some particular attention and perhaps use the courts to pay particular attention to the predicament of minorities whose participation in this process has been blocked by failures of the ordinary processes whereby minorities are incorporated. Now, Ely's position is, if that happens, then you need to pay attention to what the minorities might have at stake, which isn't properly being taken account of in the legislative maneuvering that's been going on. And sometimes, not always, but sometimes, the minority position may be a position that looks at certain interests that its members have at stake that are not being properly attended to, certain liberties that its members cherish that are not being properly focused on in the legislative solution. And the courts have to act as they think a good legislator would have acted, or a good legislative process would have acted to deal with these matters. Now, this sort of second line of argument, which builds on and complements the kind of concern about legislative process getting locked up that Sam mentioned, which was mainly structural rather than substantial. But building on it in this way establishes the possibility, not the certainty, but the possibility of a connection between this overall orientation and the rights that that particular minorities might have. Sometimes it might just be interests that the minority have rather than rights, rather than interests rising to the level of the concern and the strength that we associate with rights. But sometimes it may well be rights that minorities feel they are being silenced or denied certain opportunities or not being permitted to exercise certain liberties. And in those cases, we say, and I say as a democratic idealist, an ideal political procedure, a legislative procedure, would find ways of accommodating concern for the minority position in the basis in which the legislative process has been organized. But it doesn't always happen. And in these cases, maybe, just maybe, this is me being as respectful as I can in the disagreement, maybe allowing the judges to act as they think a good legislature might have acted may be an important contribution that can be made. I don't know whether this can work for all cases. There is an open question in constitutional jurisprudence about how much in the way of the items on the Bill of Rights can be thought to be affected by this kind of argument. But it's the argument for judicial review or for judicial intervention that I most respect. And so I was very glad that Sam set it up today. There is a question about whether judicial intervention, responding to the locking up of the political process that Sam talked about, or the failures of the normal processes for accommodating minorities that I just talked about. There is a question about whether judicial intervention always makes things better, or whether it might make things worse. It might make things worse in a couple of ways. It might make things worse by relieving the legislature of the burden of reforming itself, and making it a kind of a self-fulfilling prophecy that the legislature is going to be dysfunctional in one or other or both of these regards. It might make things worse in the sense that the judges take the opportunity simply to pursue their own convictions and their own politics and their own political positions without regard to anything other than a sort of gesture at the John Hart Ely conditions. And it might make things worse in the possibility that the justices, in their decision making, might actually contribute to the locking up of the political process, and may actually contribute to these policy failures. And I think any defense of judicial review along these lines has to be heavily qualified, heavily conditioned by attention to these possibilities. I'll say one other thing before we go back into the back and forth. A lot of what Sam said, particularly under the heading of his second argument, was that when things start going wrong in a political system, we have no choice but to turn to the judiciary. The legislature is a shambles, or the legislature have made themselves vulnerable to exploitation by the executive. The executive is power mad. The legislators are not doing the things that we expect legislators to do in anything remotely approaching an ideal theory. So who can we turn to? We turn to the justices. The justices might make things better. At any rate, we have no choice. We have to go there. And that's a possibility, and I understand the impulse in that direction. It works because in the order of institutional collapse, in the order of institutional corruption, the judges have come last. That is, they are the last institution to be corrupted. They are the last institution to fail in its responsibilities. But we have to ask ourselves, why should we believe for a moment that there's anything about judges that means that they will be immune from their own versions of the various vulnerabilities and processes that Sam has described? And let me just say something there about the way in which we have found in this country that our approach to I don't think the court is a corrupt institution. I think there have been issues about ethics recently. But certainly we have faced issues about judicial appointments and about the manipulation of the politics of judicial appointment and the basis on which that manipulation has made it possible for the politics of judicial review to be poisoned by partisan animosity relating to judicial appointments. And we've seen, many of you will know more about this than I do, in countries like Israel, the flare-up of concern about new bases for possible political appointment of judges and the increasing of the political element for the appointment of members of the Israeli Supreme Court or High Court, depending on what hat it's wearing on a particular occasion. And that has led, before the havoc that followed the atrocities of October the 7th, but for a whole year before that, there was massive anger, massive demonstrations on the streets of Tel Aviv, massive fury on the suggestions that elective politicians should have to play or should be allowed to play a greater role in the appointment of justices rather than the rather complex positions that allowed justices to be appointed by the existing team of judges who would participate in the judicial appointments process. That's one indication in Israel, in America, in some other settings, that the judiciary too is beginning to become vulnerable to the kind of concerns about personnel, to the kind of concerns about extraneous motivations, and to the kind of concerns about the freezing up of the institutional processes that courts rely on to do their work, and the institutional competence that courts exhibit or fail to exhibit with regard to their outcomes. So I think it is very, very dangerous to vest sort of 100% confidence in the proposition that the courts will always be in a position to redeem the failings of the other institutions. They may not, and if they fail, if the courts become corrupt, if court processes freeze up, if the interventions of the courts makes things worse with regard to the other institutions, then I say at that stage we have no choice but to engage in wholesale rather than retail institutional rehabilitation. We need to say, okay, we had the luxury for a while of not worrying about an ideal theory of democratic legislature. But now we have to go back to first principles to think about the reorganization of the legislature, because we can no longer rely on any other institution to come with its particular competence and with its particular institutional arrangements to solve the problem for us. And that's all I'm going to say by way of defense about doing the high-minded dignity of legislation, ideal political theory. Eventually, there's going to come a point where we have to pay attention to that stuff, because there is no shortcut to protecting the arrangements. With those two caveats, one about the judicial process itself and one about the connection with rights issues, I really do welcome what Professor Issacharoff said today.
So you got a sense there of the terms of the exchange, and Jeremy is trained in England, and so he is very polite and very encouraging while putting the knife deep between your ribs, and it was a silver knife, so I am deeply appreciative of the cleanliness of the wound. But listen carefully, because this is the kind of exchange that has been so useful for me over the years. So there are three different challenges put forward by Jeremy just now, and subtle moves from high to low. So the first one is, basically a concession that my view has prevailed. Ever since 1989, we've been minting democracies around the world. Every one of them starts with a constitutional court. Every one of them, as soon as you create a constitutional court, it only has one function, which is judicial review of legislation. There's nothing else to do. It doesn't have jurisdiction over normal criminal offenses, over normal civil offenses. So every single country created one. So Jeremy's a little bit a voice in the wilderness on this. He's well listened to, but his view has not prevailed. So he says, how's that worked out for you? And can you draw any line that would connect that vision of democratic politics under constitutional court supervision to the collapse of the legislature in country after country, and to the incredible erosion of democratic stability that we've seen in the past 20 years? That's a great challenge, but it's an empirical one. And it's a hard one because it has both a theoretical component and just an empirical question, which is very difficult to answer without a country-by-country assessment of how the politics played out, what the role of the courts were. And it's a counterfactual, but it's also true, as he says, that it raises the political profile of the courts. I'm originally from Argentina. In Argentina, over its history, the Supreme Court is an irrelevant institution because every government comes in and just replaces it. And if it gets in the way, it's thrown out by the military. So it doesn't matter. Now, all of a sudden, since the Constitution of 1994, it actually matters. So now we have massive political battles over who gets to be on the court, and that becomes a point of engagement in the society. So Jeremy's entirely right. And in the debates before last October, the debates about the Israeli court and its independence from the legislative process, actually Jeremy and I were kind of aligned on this one, both feeling, he more so than me, but uncomfortable about the claimed right of complete independence of the judiciary from the political process. I don't believe in that, because I don't think that the virtue of the institution is that the judges, by putting on robes, all of a sudden become Hercules, to refer to our late colleague Ronald Dworkin. I think that it's an institutional mechanism, and the reason that it's helpful is because when you have political capture of the institutions, the courts tend to respond asynchronously. That is, they don't come in the regular election cycles as does the executive and the legislature, so it takes longer to take over the judiciary once Orban comes in or once Kaczynski comes in. It's a slower process, so it can be a break on this concentration. The second challenge Jeremy gives, and it's a great one, is Before you go too quickly to this theory of the lockups or the process values of John Ely or something like that, look a little more carefully at the legislative process, because you may find that there are mechanisms in there that give it a democratic protection even when you don't like the outcomes. And the best example of this is the use of the shadow cabinet in Britain. And that's a body that is made up of the opposition, that has a right to hold hearings of certain kinds. It has a right to put forward policy papers. It has the right to the subsidies of the government for certain of its activities, presenting itself always as if we were in charge rather than them. This is the grounds of democratic contestation. So it's not only an effective mechanism of governance and holding the governing party to its parameters of power, but it's also a constant education of the public that these are the choices that we are making in a democratic society. It uplifts the demos. It makes us better. And it makes people who have to work 9 to 5 or longer, and who worry about their kids, and who worry about their church, and worry about their this and that, and they don't have that much time for politics. It gives them a way of understanding what the debates of society are. And so on that score, he's absolutely right that this is a level of institutional detail that we should be very attentive to. And the third, the third area where he pushes, and this is, he has scored points on me many times over the years on this, is I'm most comfortable in the domain of structures. He's most comfortable in the domain of rights. And so I start off by saying, let's take his entire concern and just, it's irrelevant, it's silly, and then let's not pay attention to it. And he comes back and says, yeah, but you're cheating, because you know at the end of the day that this is going to back up into rights. And let me just give you one quick example. When the new governments came in Eastern Europe, in countries like Estonia or Lithuania, one of the things they did was they had to restore some sense of national democracy. So great. So they created a parliament, they created this, they created that. They said, here's an idea. Let's have everybody in Latvia speak Latvian. Let's have everybody in Lithuania speak Lithuanian. Let's have that be the party of power. Sounds great. Except a third of the population is Russians who were born there after 1945 and who have never known any other country. They have no place to go back to, and they don't speak Estonian or Lithuanian or Latvian. They speak Russian. And so now you've excluded, in some of these countries, a third of the population from the democratic process ab initio. And I could say, well, that's a structural defect because of this and that. And Jeremy's response, where we'd argue about those countries, would be, oh, come on, get off it. No matter how you frame it, you're going to end up in the language of basic rights of being a respected citizen, somebody afforded equal dignity in the society. And that's a fair point. And the two polar positions that we have don't really hold up against the cases that are going to be presented in the margin. So these are the right sets of critiques, and this is the way that this has had a big influence on me.
Do you each have some closing words before we open things up to questions?
I think we should open it up to questions.
Yeah.
We don't have a whole lot of time.
Yeah.
Okay. So if you have a question to ask, please line up at the microphone. Keaton, let's start with you.
Okay, so I hope this one follows nicely. And the question I have is probably for Professor Waldron, maybe for both, is to what extent is judicial review a substitute for exit? And so you see democratic theory, originating in a time where you have dissenters leaving places. You have a lot of land in which people can occupy and go and disappear. We have establishment in religion, and as society has shrunk, right? There's just less federalism. There's less sort of autonomous spheres of being, and so. Do you think that judicial review has to substitute for that gap?
I can imagine somebody making an argument in regard to some particular issue that, in fact, that's the configuration to think about. Abortion rights seems to be a version of that, where somebody says, look, if we don't have abortion rights guaranteed by a court, we're not going to get them guaranteed by the legislature, and we're going to have to move to Canada, or we're going to have to move to Mexico or whatever.
Or
in
New
order
York, New York, just as bad.
Right, sorry, excuse me, from state to state, that's exactly right. Now, we don't want to defend judicial review simply on the basis that it substitutes for that process, but it helps illustrate the concerns that judicial review might be responsive to. I think it's possible that judicial review can be exercised in another direction so that it's a judge's decision that makes it imperative for people to move to a different state or a different country. But I don't see it as a simple substitution. I see it as an issue-by-issue question.
Hannah.
Thank you. Hi, thank you both very much. Sorry if this question veers more to the question of philosophy than one of law, but granted that judicial review is a question about whether or not it's a democratic practice, I was wondering if you both could speak to your conceptions of democracy and how that plays into each of your views.
You want to go first?
So over time, I hearken more and more toward the view of democracy of Joseph Schumpeter. That is, that the force of democracy is the retrospective accountability of the governors to the governed. And the ability to throw the bums out is what defines a democracy. And so I move from that perspective to keeping open the channels of competition so that they both have, the parties, the political elites have to educate the masses and also be accountable to shifts in preferences. So a lot of the work I do is derived from that first order principle.
Yeah. I think it's important to see, in a slightly more philosophical vein, the connection between democracy and political equality, and the connection between democracy and respect for the various citizens that are participating in the political process. And we try to set up mechanisms. We don't do it by any means with any approach to perfection, but we try to set up mechanisms, including majority decision, including majoritarian elections, which take the vote and the voice of each person as seriously as it is possible to take it, and give it as much weight, each of the millions of participants, give them as much weight to each of their voices as is given to any other voice in the formal processes of the society. So, Hannah, I see that as being crucial in the engine house of the philosophical ideas. I'll just add one other thing. There are a lot of people who say, well, you can't have a democracy unless you have other rights that are guaranteed. So democracy has to have a substantive as well as a procedural component. And I can see why that works for things like freedom of political association, freedom to form political parties, freedom to display loyal opposition, and so on. For other arguments, I see it as a more tendentious relationship, and I wanted just to acknowledge that that argument exists. And I would probably want to be very, very wary of any attempts to incorporate substantive criteria into the definition of democracy.
Could I ask a follow-up question? Is that okay? Okay. No,
We've got a big queue, so let's
okay.
just hold off. Thank you.
Sorry, thank you.
Hi. So when I think about the great room of democracy, I think about the little space between my counter and my fridge that's almost impossible to clean without moving the refrigerator. And I see judicial review as a thing that can move the refrigerator. And I think that, you look at Flass v. Cohen, Justice Douglas pointed out that the courts are really the only accessible point we have in a system of governance as complex and huge as ours. So like in a 300-page bill, that's going to affect the lives of 350 million people. I think a bill like that makes each and every one of us a discrete and insular minority in some type of way. Because even without any malice, just through sheer carelessness, they could have a policy that completely uproots the lives of a large number of people, but not large enough to be electorally significant. So my question is, if not for judicial review, what other recourse does that group of people have in a democratic system?
I certainly want to respond to that because I think it is the case that not an ideal legislative system, but even a halfway ideal legislative system has multiple points of access for people to participate in the decision making. And while eventually, when a bill is settled upon and committed and goes to the stage of voting, at that stage we might say, I'm a discrete and insular minority with regard to the particular compromises that were made. I've been locked out of this and I've been locked out of that. But it wasn't for lack of trying, and it wasn't for lack of input. Now, that said, I think it is important for somebody like me to acknowledge that there's an important lobbying aspect of judicial review, that it affords a differently shaped but different kind of political access, where a citizen or a person with some grievance can state their grievance in principled terms, intervene in the space between the cupboard and the refrigerator, if that's what we have in mind, and expect their intervention to be seriously and steadily considered as a matter of principle. And that is a valuable thing in a political system. I'm not saying that it's always a substitute for victory in the legislative stage. And I do say that eventually we have to come back to having a good theory of the respective positions of each of the institutions that we have in mind, the agencies, the legislature, and the courts, as offering complementary intervention opportunities to the citizens.
I think your question actually presupposes that the way that this problem is handled is through the formal institutions of the state. And I think if you look at the history of successful democracies in the period of democratic ascendancy, the last 200 years, what you find is that the major institutions that address the problems that you're raising are not necessarily the state institutions, but intermediary organizations, be it the trade unions, the chambers of commerce, the churches, and the political parties that are based upon those. Those have been the transmission mechanisms for the concerns of ordinary people. I mean, if you want to move a refrigerator, given the age of our Supreme Court justices, I'm not sure that's where I would turn. I think that what your question presupposes is that democracies function at the level of these formal institutions of the state. And I mean, this is going far afield, but that was Madison's fundamental error in the political theories advanced in the Federalist Papers, that they thought it would all take place at that level, and the citizens were down below just to ratify through the electoral mechanism. It turns out that from the beginning, democracies were built through these intermediary institutions, and many of our problems today are the failings of those intermediary institutions. I don't think this is an argument for the expansion of the role of the judiciary. I think it's a fundamental question of our time of how democracy will reorganize itself in the absence of these successful intermediary institutions.
Thank you.
Thank you so much. My question, perhaps primarily to Professor Waldron, is I wanted you to comment on Larry Kramer's conception of popular constitutionalism, because I imagine he might accuse you of overstating the extent to which judges have this power and whether court judgments actually interact broadly with the public. I think he gives the example of Dred Scott, then the Civil War, or the switch in time that saved 9, this reality that every time the courts give a ruling that the majority of the people do not disagree with, courts are always forced to recede, and the fact that judges are not exercising that power in isolation, but in fact they are still subject to majorities even after making rulings.
Yeah. I have a great deal of respect for those who have developed versions of popular constitutionalism, and I do think that we need to emphasize the ways in which pressure is brought to bear on courts to toe a certain line in regard to the issues, the political issues that they deal with. I do think that when we talk about popular constitutionalism, we should emphasize a couple of things. One is that the function of a constitution is not just to limit government. Often the function of a constitution is to empower government. Often it is to empower people who would normally otherwise not be empowered. Empower them with votes, empower them with political standing, empower them with status. And keep an eye on that empowerment to make sure that it doesn't decay and doesn't get degraded. And I think it's very, very important for a popular constitution, a popular approach to constitutionalism to bear that in mind. Constitutionalism is too often defined in terms of limiting government rather than empowering government and empowering constitutive aspects of citizen participation in government. So that's one question I think that's important, and I would want to give a lot of attention to the possibility that constitutionalism should be understood in those terms. A second point would be that we have to understand that what courts do is not the only occasion on which constitutional values are brought to bear in the political process. If we take popular constitutionalism seriously, we take seriously the constitutional consciousness that citizens have and display when they participate. And heavens, we take into account also the constitutional consciousness that representatives and senators have in mind when they participate. We don't assume that judges have a monopoly on constitutional consciousness, or that somehow the oath which various political participants participate only means something in the case of the justices and not in the case of the legislator or the senator, or for that matter for the president. So in that sense, taking seriously the sense of constitutional obligation that elective branches may have means that we are reluctant to concede a monopoly to the non-elective branches in the maintaining of proper constitutional consciousness. I mention this just because the court has occasionally disfigured its position by saying we're not required to pay attention to the constitutional consciousness of the Congress in passing this piece of legislation. You remember in City of Burney against Flores, they suggested that other branches are free to form their own opinions, but they must understand that we will pay attention only to our own precedents and our own decisions, not the decisions of it. So just for that reason, I think that the constitutional consciousness aspect is important. But equally, the first point that I mentioned, I think, is very important.
Thank you both for being here. One thing that both of you alluded to is kind of the idea of there being a proper balance between the power of the judiciary, the executive, and the legislative branch. And thinking about recent Supreme Court precedent, Loper-Bright, the major questions doctrine, things like that, there does seem to be a trend toward removing decision-making authority from the executive, but it seems to be a bit of an unresolved question whether those powers are being redistributed to the legislature or to the judiciary. And I'm curious to hear where each of you thinks that process is ending up, or if it may be too soon to tell.
I think that you're asking for many trend lines in Supreme Court jurisprudence to be reconciled. I happen not to think they are easy to reconcile. I argued and lost a case in the Supreme Court a couple of years ago called TransUnion versus Ramirez, and in which the court said that when Congress establishes a cause of action for the violation of a federal statute, they can do that, but they can't bring it in our house. They can't bring it to the courts. And so that was a rather radical constriction of the power of the legislature vis-a-vis the other branches. The Chevron revisiting changes it in another direction. I would not venture that there's a coherence there at this point.
Thank you both for being here. My question is about electoral constraints in the judiciary and whether or not having more elected judges or more term limits impacts how you think about judicial review.
I mean, certainly term limits are worth considering, right? Long-term limits, but term limits nonetheless. As for the election of judges, I know it's a peculiar custom that, particularly at the state level, judges are elected, even on the highest state courts, they're elected. The difficulty that I have, and I'd be interested to hear what Sam has to say, the difficulty is we don't have a good theory of judicial representation. We don't have a good theory that connects the electoral basis of the judicial appointments in those states with a view about the accountability that judges should have to their constituents, or the way in which the promises they make during their election should affect the way they carry out their duties. Until we have a good theory of that, and I'm not about to contribute, until we have a good theory about this, this seems to be an anomaly.
Yeah, early in my career, I litigated a couple of cases that were the first challenges to how judges were elected at the state level under the Voting Rights Act, under a theory that if they're going to be elected, there should be equal rights under statutory rights for black citizens in various places. And the problem then and now, as Jeremy said, is that the courts were asking, well, what's the theory of representation that carries over to the judiciary? How does that work? Does, for example, does one person one vote apply? And there's jurisprudence that says it doesn't. But at a deeper level, this goes back to the last set of questions on the last answer on popular constitutionalism. I think the justification for judicial intervention is precisely when it's counter-majoritarian. And I dislike intensely judicial opinions that take the form of, we read the majority of the population to want X. If the majority of the population wants X, this is not a job for you. This is exactly the domain where I would agree with Jeremy. This is not for you. So the idea that we want judges to be a microcosm of the electorate when what we are worried about is systematic distortions by the majority or prejudice by the majority, so we want judges to be more reflective of that majority, I don't get off the ground with that argument. And so it's hard if you don't accept the premise, it's hard to construct an argument about what the proper measure of representation should be.
At the very least, you would have to map the structural account of the legal process onto the conditions of judicial representation. I'm not seeing how such a map can be constructed.
Quick final question.
This piggybacks perfectly off the previous question, but I'm kind of wondering how, in terms of democratic legitimacy, you understand the difference between citizens electing representatives who then choose the laws on their behalf and vote on those. And then assuming the citizenry all knows that the Supreme Court has no term limits and all these things, electing a president who then elects these people. Like right now in this current environment, we all know that the president that we're voting for is then going to elect a Supreme Court justice who's going to make decisions based on those views. So it seems in that sense like there is some sort of democratic play.
I think that there has to be a measure of political involvement in the selection of the judges. Otherwise, judges standing apart from the society, I don't have a platonic view of the judiciary, and both of us over the years had disagreements, stronger and less strong, with our colleague Ronald Dworkin, who thought that the judges, once in office, would answer to a higher call and to the norms of the best norms of the society. Judges are institutional actors, and they have to reflect at a distance the political process. They shouldn't reflect, in my view, the immediate political interest, but they should reflect at a distance. And so you're going to have political processes that come in. I agree with Jeremy that you can tone down the politics of it through selection. My preferred mechanism is the German system, where you have two chambers of the Constitutional Court. They serve for 18 years. Every 2 years, one member of each chamber goes off and they're replaced. Yes, the politics comes in, but the politics are muted because it doesn't seem cataclysmic. I was just in Taiwan, where they have very short tenure for Supreme Court, for Constitutional Court judges of only 8 years. And right now, 5 of them are up for reappointment. So the political dynamic is so fraught because everybody realizes it's the whole control of the court. So they're projecting onto the election the decision in each of the major cases that's pending before that court. So I think that we can respond institutionally to tone down the politics, but I never want the politics to come out of it altogether.
Particularly considering the role of an elected president and elected senators in nominating and confirming justices, that certainly involves a scintilla, a tiny amount of democratic legitimacy for the judicial appointments. But it's always comparative. And here in this discussion, in this controversy, we are considering the comparison between judicial decision-making and decision-making by legislatures. Now, I think what you've established is that there is an indirect form of democratic legitimacy, remote but indirect form of judicial legitimacy based on the conditions of appointment. There's probably also a scintilla of democratic legitimacy based on the mode in which people have access to judicial intervention through litigation and so on. But if you compare that to the dense, complex, rich democratic legitimacy of legislative processes, which are also indirect, there's no doubt about that. We're not talking about participatory democracy, but they involve participation at a number of different levels, and they involve at their best or even at their second best. They involve political participation and political equality at level after level. They all are conducted in the shadow of the overall elective mandate, and they're conducted in the shadow of the overall respect for the participation of citizens. So for me, there's no contest here, even when I acknowledge the scintilla of democratic legitimacy.
Thank you very much, and thanks to all of you for attending, and please thank Sam and Barry. Thank you.